Yes. So can we move ahead? So see, in the last discussions, whatever we had till now about the introduction part and all, we were discussing about document instrument several times. We've used several times the term of document instrument. So let us understand what do you mean by this term document instrument technically. I mean deed to document instrument and deed, and let us understand what's the difference between all these three terms. Very very important for your examination, and there is being a drafting subject. It is mandatory for us to understand. It's very very necessary for us to understand as to how what do you mean by a document and how it differs from the instrument and a deed. Clear? So write down, keep the heading document. Document. Yes. Let me write the definition first of all, then we'll understand it. So anything written, expressed or described by way of figures, marks or words on any substance, on any substance which provides evidence, proof or information, then that substance will become a document. So it has been defined under section 3 subsection 18 of General Clauses Act 1894 amended 1897 defined the term document as anything written, expressed or described by way of figures, marks or words on any substance which provides evidence, proof or an evidence information. The substance is a document. Clear? Not clear? Yes. Now listen here. Anything. So anything it is, or I don't know, drafting, anything. So anything that is been written or expressed or described, so maybe in words or you have expressed in a particular logo likewise, on any substance. Very important, any substance it may be. So not compulsory a paper, not compulsory a paper, any substance which provides a evidence or a proof or information, then that substance will become a document as per General Clauses Act, But we have so many definitions for the terms for a specific act. Like we say for a Companies Act 2013, it talks about the documents, the papers, records what you have. So likewise, depending upon the act, we have the definition for the term document. But if at all you look into the General Clauses Act, it depends as to whatever you write on any substance which is giving you some information, then that substance is nothing but a document. Say for example, I have a AC remote. Now anything, there is something written and expressed both on the words and the logo of that particular manufacturer on a substance, the substance being a TV remote here, which is giving me an information about the manufacturer details and the the symbol of that particular manufacturer, then the substance is nothing but a document. So it need not be a paper which has to be a document as per section 3 subsection 18 of General Clauses Act. It may be any substance, which gives you some information, that is enough. That's a document. On the public roads, you can find the the hoardings with respect to the distance and the other part. Is it a document? Yes, because it is giving some information where or substance, something is written or expressed on a substance by way of a route maps or by the route distance on substance, which is giving you a proof or some evidence or some information as to about that particular route. So that substance, that is a hoarding, have become a document. A notice of an AGM is a document. Yes. Anything? Yes, it is even described on a paper by way of words and the figures, which is giving you a proof or an evidence that a company is going to conduct or conducted or convened an AGM on so and so date at so and so place. So be it a paper or any other substance which is giving you some information or an evidence or a proof that by virtue of that, then that substance will become a document. Clear, everyone? So that is a concept of document. Next, instrument. So what it says about as per section 214 to subsection 14 of Indian Stamp Act. It says includes every document by which a right or liability is created, recorded, extinguished, modified, transferred, etc. So this is how the Indian Stamp Act defines the term instrument as. So how it's referring? Includes every document. That means to become an instrument, it has to be a document first of all. So every document by which a right or a liability is created, recorded, extinguished, modified or transferred, then that document is turning out into an instrument. Didn't understood? Now listen. See, we used to have the habit of writing on a car full of dust. I mean, if at all you have a car full of dust, likewise, this is a dust, say for example, then we used to have a habit of writing our name like this, right? Now, have you written that? Yes, of course, you've done. Now, is it a document first of all? Yes. Why? Anything? Yes, something. On any substance, a car, which is giving you some information. What information? Some name, that's it. I have never said it is a legal information. Some information, yes. So, it is a document. Now tell me, by simply writing your name on that car, does that car belongs to you? No, obviously no, because you say that the car belongs to neighbor person, you have written your name. So does that mean that that car belongs to you? No. That means, sir, the document what you have made over there, if the document is creating a right or liability on part of you, or if it is extinguishing a right or liability, or it's modifying a right or liability, then in that particular case where some right or liability is involved by virtue of the document, then that document turns out into an instrument. Say for example, you have paid me the fees. You paid me the fee. For that, I have written the receipt in the name of so and so, signed by me. Now, is it a document first of all? Yes, that is a document. Why? It is giving you some information or some evidence, a proof that you have paid some amount. Now, is it an instrument? Yes. Why? Sir, it is creating a right on you to attend the classes, and it is creating a liability on me to provide the lectures to you. So, by virtue of this document, a right and a liability is being created. Then this document is more precisely called as an instrument as per section 2 subsection 14. Say for example, a lease deed has been executed for a period of 5 years and that 5 years has been expired. Now you intend to renew that agreement for a further period of 2 years. Your rights have been modified for a further period of 2 years. Or say for example, you are subletting that. Sublease. You are transferring your rights in favor of another person. You are surrendering back the property. Then you are modifying, you are extinguishing your rights. Clear everyone? So this is a instrument where a document which is creating a right or a liability or modifying a right or liability, then the document turns out into an instrument. Clear everyone? Turns out into an instrument. Now tell me, IPC or CRPC, CPC, is it an instrument or a document for you? Is it an instrument or a document for you? Think and say. First of all, is it a document? Yes, it is giving you some information or evidence. Yes, that is a document. Is it an instrument? Creating a right or liability? Tell me, have you murdered anyone? Assuming that you didn't, whether CPC is applicable for you, CRPC or IPC is applicable for you? No. See, unless I commit an offense under that particular act, that act is not going to govern me. The code is not going to govern me or limit me. Unless I being a company secretary, or say for example, I being a layman, I am a farmer in a remote village. Tell me, Companies Act is applicable for me or not? No. Because I'm not a shareholder, I'm not a director, I'm not a company secretary, I'm not a debtor, I'm not a creditor to the company. See, up to if at all you go onto the roots of stakeholder, you may be a stakeholder, but as you being a stakeholder, what will be your rights? So, Companies Act is not going to govern you in any sort of manner unless I come under the purview of that particular Companies Act, where I may become a company secretary or some position of the Companies Act, or becoming a director, or becoming a shareholder, or becoming a debtor or a creditor likewise. So all your parliamentary legislatures are documents, and that will be an instrument for that individual to whom this act is applicable. Clear everyone? Constitution of India, that is an instrument because by virtue of your birth that is applicable for you. Clear everyone? This is the concept of instrument. Now tell me whether the document is wider or instrument is wider. Correct me. All instruments are documents, but all documents are not instruments. I repeat, all instruments are documents, but all documents are not instruments. True. Because see, everything that you take where you provide some information, that is a document, and out of the document which is creating a right or liability, or any sort of right or liability is involved, only those things will be regarded as an instrument. And everything is a document. Clear, everyone? Clear? So say for example you got an order from a court of law with respect to a particular case which has been filed against you. So you have got a right, that is in your favor. So you have got a right. So that order what you receive from the order court, that is nothing but an instrument, because it is creating a right in your favor. A will, where it is creating a right in your favor, so that is your instrument for you. So a document which is creating or modifying or which is involving a right or liability, then that document turns out into an instrument. Clear, everyone? That is the concept of document and instrument. And the last one, deed, and there is no statutory definition for this. No statutory definition. And likewise, so many authors have defined the term deed, and one amongst them is Mr. Norton, Norten, Norton. Mr. Norton, who defined this term deed as in writing on paper, volume, or parchment, then signed. One second. Parchment, signed and sealed, and delivered, Sir, anything that has been writing on a paper, volume means on a walls, parchment means on the animal skins. So we used to write likewise in ancient time, which has been signed and sealed, or in case of an artificial person it will be signed, and delivered to the other party, by which a right is being transferred over a property or over a person, then that instrument will be turning out into a deed, whereby, see, it is involving certain right, that means obviously it has to be an instrument, and if that instrument is being delivered, then that instrument turns out into a deed. So the essence over there with respect to the concept of deed, it is about the delivery of that instrument. It is about the delivery of the instrument. So as soon as you deliver the instrument, then that instrument turns out into a deed. Clear, everyone? So tell me whether the deed is a wider term or a document is wider term. Document is a wider term. All deeds are documents, but all documents need not be a deed, because a document may or may not create a right, and that may or may not be delivered. Clear, everyone? So three things we have understood: document, instrument, and deed. Document, anything that you write on any substance which is giving you some information or a proof, then that substance is a document. And if that document is creating, modifying, or extinguishing any sort of right or liability, then that turns out into an instrument. And if that instrument is which is in writing, signed and sealed, and is delivered to the other party, then that instrument turns out into a deed. Clear, everyone? This is very, very important question for examination for 8 marks or 4 marks. Every alternate or almost every attempt is asking the questions. So we'll quickly revise this topics. So explain the terms. Document. A document is a paper or other material thing providing the information, proof, or evidence or of anything. Section 3 subsection 18 of General Laws Act 1894, defined in 1897, states that a document shall include any matter written, expressed, or described on any substance by way of a letter, figures, or marks, or by one of those means, which is intended to be used or which may be used for the purpose of recording the matter, that is for information, proof, or an evidence, then that substance will become a document. Substance will become a document, where all deeds are documents but all documents are not deeds. A document under seal may not be a deed if it remains undelivered. Clear? That is example, a will, an award. Examples: writings, word printed, lithograph, photographs, a map, inscription on a metal plate or a stone, a caricature. So everything that you take on this universe which is giving you some information, that is nothing but a document. Instrument. Section 2 subsection 14 of Indian Stamp Act 1899 defines the term instrument as including every document by which a right or a liability is purported to be created, transferred, limited, extinguished, or recorded. Sir, by virtue of your document, if any sort of right or liability is involved by way of a creation or modification or transfer, then that document turns out into an instrument. It may be noted that all instruments are documents, but all documents are not instruments, need not be an instrument, because it may involve a right or not. If at all it is involving, then that is an instrument, otherwise not. So how you need to check out document? Out of that, right or liability involved, not involved. The right or the liability involving maybe with respect to creation, modification, recording, transferring, extinguishing, whatever it is. If at all that is involved, that is an instrument. That is an instrument. If not, then that is only a document. Now if at all that is instrument, you need to check it out whether it is delivered or not delivered. If delivered, then that will become a deed. If not, it is only an instrument. This is how you need to check out. So the term instrument includes the awards made by the industrial codes, the will, the decrees from the different authorities. However, it does not include the acts of parliament unless there is a statutory definition to that effect in any act. So unless you come under the purview of that particular act, it is not going to govern you. And the last one, the deed. The term deed normally used to describe all the instruments by which two or more persons agree to effect any right or liability. A deed may be defined as a formal writing of non-testamentary character which purports or operates to create, declare, confirm, assign, and limit some right, title, or interest. A deed in writing, as per Norton, it is a deed in writing on a paper, volume, or a parchment, sealed and signed and delivered, very important, whereby an interest, right, or a property passes, or an obligation binding on some persons is created, or which is an affirmation of some act whereby an interest, right, or property has been passed. So whatever the rights or the liabilities that is being created or modified, where it has been delivered, then by virtue of that it has become a deed, where it is a present grant rather than a future promise what you make. So it is what it says, present grant rather than the mere promise to be performed in the future. And all deeds are instruments, but all agreements, that is all instruments, are not deeds, because it may or may not be delivered. Clear, everyone? And this is the important concept with respect to document, instrument, and deed. Clear, everyone? Clear? So this is what we have discussed in the today's session. In the next session, we'll be talking about the next topic, that is principles of drafting. Clear? So until then, take care. Bye bye.